Hi, everyone. I'm Howard Walthall with Venture Medical. I want to thank everyone for attending. In honor of our guest, David Traskey, who's a lawyer, our lawyers share the following disclaimer with you. The views and opinions expressed in today's presentation are those of the speaker and do not necessarily reflect the views, policies, and positions of Venture Medical LLC, its affiliates, or partners. This content is for educational and informational purposes only and should not be interpreted as legal, financial, or compliance advice. Venture Medical assumes no responsibility for actions taken based on this presentation. Before I introduce the presenters, just to note that they will be answering questions at the end of the presentation. So if you have any, drop them in the chat. I'm not guaranteeing we can get to all of them, but we'll do our best. So on to the presenters. We're very pleased to have David Traskey and Dr. Dan Kapp as guests today. Mr. Traskey is co-head of the Washington, D.C. office of Garfunkel Wild, a nationally recognized healthcare law firm. He is a former senior counsel with the U.S. Department of Health and Human Services, Office of Inspector General. He focuses on fraud and abuse matters, compliance strategy, and government investigations. He is also a certified fraud examiner with extensive experience guiding providers through audits, overpayments, and self-disclosures. Dr. Daniel Kapp is a board-certified plastic surgeon and nationally recognized expert in wound care management using advanced biologics and innovative technologies. He serves as chief of surgery at Palm Beach Gardens Medical Center and is the founder of MEDNAC, a consulting firm that supports providers facing audits and regulatory scrutiny. Dr. Kapp has co-authored leading consensus papers on the use of cellular, acellular, and matrix-like products, CAMPs, and is actively involved in clinical research advancing chronic wound healing. And on a more personal note, Dr. Kapp shares fantastic and fascinating information about the history of wound care on his LinkedIn profile. So if you're not following that, you absolutely should. It's kind of astounding. With that, I'm going to turn this over to Dr. Kapp and Mr. Traskey. A reminder that a recording of this presentation will be posted to our YouTube channel and you'll receive a follow-up email when that is ready. I think, David, you're starting first, but I'll turn it over to you.
Great. Thank you so much, Howard. I appreciate it. So I want you to picture this. You're sitting at your desk on a random Friday afternoon, and you get a phone call from a number that you don't recognize. You pick up the line, it's somebody from the OIG, and they're asking to speak with you about your growing use of skin substitute products or CAMPs. So this pit in your stomach starts to grow, and you think, OMG, it's the OIG, right? And in your brain, you're probably also starting to think about a few four-letter words that you want to shout into the other end of the phone, right? Thankfully, you don't do that. But it's a totally normal feeling to get when the government calls you and they start asking you questions about your practice. And so if you stick with us through the end of the presentation here, I promise you, I will share with you my favorite four-letter word that I use when things are not going my way. Howard, are we good on volume? I got a note here that said someone couldn't hear. We're good? Okay.
I can hear, so I think it's probably local.
All right. So let's see, get this going. All right, so today we're going to talk a little bit about what to do when the government comes knocking, because if you are using skin substitutes in any capacity, whether you're a distributor, a manufacturer, a provider, it's really, from our perspective, from my perspective, being in the OIG for many, many years, that it's really not a question of if they'll come knocking, it's a question of when they'll come knocking. And that's particularly true given the really absurd amounts of money that the government has spent on these products in the last couple of years, in particular into the billions of dollars. And it's almost a near certainty that you'll hear from someone at some point. Now you may be thinking, well, with the physician fee schedule changing here in the next little bit, maybe that concern will go away. Maybe, but understand that the government look back period for all of these types of claims is 6 years. So even if things happen with the physician fee schedule, I can guarantee you that the government is going to be spending a lot of time in this space for the foreseeable future. And so kind of with that in mind, what Dr. Kapp and I want to share with you today is a couple key learning outcomes, key pieces for you as you go through this process, right? One of the things that people always say to me when I was at the OIG is, oh my gosh, it's a black hole and we have no idea who we're talking to or why they're calling us. Right, so one of the things that we want to sort of lift the curtain a little bit and show you that there are different components within the OIG, and that's important because it's really helpful to know who you're talking to, because that should give you some insight into where things stand with a particular audit or an investigation that may involve you or your practice. We'll talk a little bit about best practices for responding to government inquiries, and then building the right team if you're going to continue to operate in this space. So first and foremost, I'll just start with a little bit of a background. This is a general organizational chart of the OIG. The counsel to the Office of the Inspector General, that's where I spent over almost a decade. And I also worked in the affirmative litigation branch and the administrative and civil remedies branch. You may be familiar with them. I'm hoping not, because if you are, it means you've probably had some sort of an audit or investigation. But you also may be familiar with the Office of Audit Services or the Office of Evaluation and Inspections, maybe from reading their reports. So we'll briefly kind of look at a little bit of these little bit behind the scenes of these components, and so you understand what's happening when you get these types of outreaches. All right, so the Office of Investigations, right? They have criminal, civil, and administrative liability. And when you're being contacted by the Office of Investigations, it's usually for one of two reasons. Either they believe that you have information that's relevant to the case that they're working and they're going to ask you to produce that information, or it's because they think, or because you are the target of their investigation. And if you're getting contacted from the Office of Investigations, you should presume that the U.S. Justice Department is involved. And that means then you have either civil or criminal liability, which is obviously a serious matter. When OI contacts you, you can ask them whether you're a target or not. Depends on the investigator. Some will be straight shooters with you and tell you yes or no. Others will play coy about it, but you can always ask. Similarly, if you get outreach from the Office of Investigations, you should ask, is the Justice Department involved? And if so, is this case being handled by Main Justice in Washington, D.C., or is it a delegated case that's being only handled by the local U.S. Attorney's Office? And when Main Justice is involved, they're using the local U.S. Attorney's Office also. But obviously, if the Main Justice is involved in Washington, D.C., it typically means that it's a more high-profile case, bigger dollars, more concern, as opposed to something that Main Justice just lets the local U.S. Attorney's Office handle. If you get a phone call or you get outreach or you learn that the civil department of the U.S. Department of Justice is involved, then you can at least breathe somewhat of a sigh of relief. Because if you're getting contacted by the civil DOJ, then you can know that the case was looked at least criminally, and that for a variety of reasons, whatever those reasons may be, maybe strength of the evidence, maybe the dollar amounts at issue, the criminal team has decided to pass on that case, and they've referred it to the civil AUSAs. And so you consider yourself lucky in that regard, because it's one major bullet that has been dodged. Here also too as well, you'll see on the slide, one of the other things that OI does is they work closely with the Office of Audit Services and the Office of Evaluations and Inspections. And they also partner with state and local law enforcement. Let's just talk a little bit for a minute about OIG enforcement actions. There's three different types of actions that are out there. One is criminal, the other is civil, and then the last one is administrative. So if you're talking about criminal cases, I want you to think Law and Order, for any Law and Order fans that are still out there. Unfortunately, these cases are not solved in an hour, but the criminal cases obviously are the most serious types of cases that there can be. proof beyond a reasonable doubt. So it's a very high burden, but these are the types of cases that go before judges and juries and could land you in jail. From a step down from that, you have civil cases. Again, still a judge and a jury. These types of cases are commonly things like Federal False Claims Act cases, and the proof for these cases is lower, right? It's a preponderance of the evidence, which basically means that the government has to prove that by a 51% chance or more that the thing that they're alleging actually happened, right? And then lastly is the administrative cases that the OIG can bring. I did several of these in my time there. If you appeal these, they go before an administrative law judge. Really, the issue here is no jail time, but the potential for having to give up a lot of money is a possibility. The Office of Counsel to the Inspector General, the Affirmative Litigation Branch, that's where I spent most of my time. The OIG has over 40 different authorities under its civil monetary penalties law, and they can also exclude providers and others from participating in the federal healthcare programs like Medicare, Medicaid, et cetera. And so, you know, this is a relatively new branch within the OIG. But really its purpose is to kind of fill in these enforcement gaps. So if you remember, we talked about DOJ civil cases, DOJ criminal cases. DOJ may pass on these cases for a variety of reasons, but they might still be valid cases. And so that's where sort of OIG steps in. And they also do their own, you know, investigating, and they can bring cases in their own right. And so the purpose of this really, again, is to sort of fill in that enforcement gap. And the cases typically come from a variety of different sources. They can come from OIG's hotline and complaints that way. Proactive data analysis and the use of AI is growing tremendously. When I was at OIG, I heavily relied on data analytics to help direct me in terms of looking at providers that may be outliers in certain categories. The amount of data that OIG has access to is pretty astounding, and they continue to sort of vacuum up more and more data as it becomes available and it goes into their system, and it continues to help let them identify folks or practices and providers that may be outliers in a variety of different categories. The Affirmative Litigation Branch also gets referrals from DOJ, as I mentioned, from the Office of Audit Services, and then from the Office of Evaluation and Inspections, based on the reports that those components issue. They also get referrals from the Medicare Administrative Contractors, the Unified Program Integrity Contractors, the State Medicaid Fraud Control Units, or the MAFUCUs, and even open source news articles might pique their interest and lead to a report or an inquiry or some sort of investigation. Lastly, what I would say is if you have been dealing with the if you have been dealing with the Justice Department and all of a sudden they stop communicating with you and you're all of a sudden contacted by somebody at the OIG's Affirmative Litigation Branch, you should know that, you know, this is a good thing because DOJ most likely has closed their civil or criminal case against you and has referred it to the OIG for administrative action. DOJ rarely will tell you that they have done this, but if this happens in your case, you should consider this development a win for you because the Affirmative Lit Branch is very mindful about interfering with cases that DOJ may be operating. So they won't do it. And so if you're dealing with DOJ and then all of a sudden you're dealing with OIG and DOJ is nowhere to be found, it's probably because your case is now an administrative matter. So a couple different things in terms of case types. I want to go back for a second. Case types. We talked about case types, right? The most common case types that the Affirmative Lit Branch is looking at is really things like kickback conduct, false billing. They also do a fair amount of work in the space of grant and contract fraud. these sort of are the bread and butter for the affirmative lit branch, because these cases have sort of the most straightforward rules and regulations. And it's important to know that when the affirmative lit branch is bringing a case, they're going to do it under multiple theories. Maybe it's going to be medical necessity. Maybe it's going to be failure to comply with applicable rules and regulations. Could be known retention of an overpayment, insufficient documentation, right? There's a lot of different theories that they're going to use, and they're going to use them in connection with each other because it allows them the most flexibility when they are bringing cases against providers or other entities. It's also important.
David, can I ask you a question?
Sure.
Has, to your knowledge, though, like using skin substitutes, the OIG has not, at least far as I know, go after a sort of regular physician in a regular practice taking care of patients the right way with proper documentation, right? I mean, they're really looking, at least right now. I mean, do you have a sense of what it is? Because I know this stuff seems kind of scary. So
yeah, I think that's right. One of the sort of the key hallmarks of what OIG does is they are not out there to try to play gotcha, right? So they'll go where the evidence leads, and if the evidence shows that you have a provider who is using skin substitutes in a medically necessary, reasonable, and appropriate way, they're doing good documentation, the patients are improving, all of the good things are happening. OIG may poke around in there and ask for some records, and then very quickly, I think they'll move on, because they're not looking to make something out of something that isn't there, right? Because frankly, there's plenty of other work that they can do. But I think it's a great question. With respect to the different investigative tools that OIG has at its disposal, they can issue you subpoenas for documents. They can compel you to testify through a testimonial subpoena. And they also use experts periodically. And I think that their use of experts is very small relative to the use of experts in the Medicare appeals process, which Dr. Kapp will talk about a little bit later. But it's important to recognize that most all of cases that the OIG brings settle. If for some reason there is litigation, typically it starts at an administrative law judge level in the Medicare appeals process. It's the same process. And ultimately, if you go all the way through the process, you will end up in federal court. And sort of during the course of an investigation, OIG will share data with you and other information, and they'll give you opportunities to respond and to provide supporting evidence to refute or rebut what they think is happening. I would say, a lot of the cases, some settle quickly, some don't. A lot of it really honestly depends on responsiveness and being a good communicator, right? So if you're faced with this issue of having to deal with OIG, one of the things that's important is to be responsive and to be a good communicator. It goes a long way to showing OIG that you're taking the situation seriously and you're not blowing them off. So here's what I want you to understand sort of for this section. OIG has many different components. Each one has its own function. Knowing which branch or component you're dealing with is critically important if you get contacted by the OIG, and knowing a little bit about who you're dealing with will help you understand kind of what track you're on and where things might go. Again, OIG has investigation and enforcement capabilities. They are a federal law enforcement agency. I think a lot of times providers think about only DOJ, the Justice Department, in that capacity, but understand that OIG has those capabilities too. Just here's my own sort of public service announcement. Remember that OIG has a self-disclosure protocol. If you're doing something proactively and you see a problem, it may be in your interest to use their self-disclosure protocol. There's a lot of reasons to do it, including saving time and money. If we have time, we may touch on that a little bit later. But here's the other really important takeaway, right? It's in the skin substitute space more so than others. It is so very important to be proactive and to stay informed about what's going on. OIG publishes a lot of reports. They have work plan items that they publish so that you are aware of what's happening. There's also, the settlements in the skin substitute space in particular are highly publicized, whether they're coming from the Justice Department or the OIG. And kind of being aware of these different avenues is probably as close as you'll be able to get to having a crystal ball as to where the government is going, what they're doing next. But I would also say, part of the proactivity on your side as a provider, on the provider side, is making sure that you're doing internal audits to make sure that your documentation is up to snuff and that you've got, a compliance plan and program in place to help you navigate this new reality.
David,
Yes.
about, and I think you're going to get to this, but about 4 or 5 weeks ago, I got calls and emails and, from people all across the country that the OIG had requested a record. And there are probably people on the phone call here that had the OIG request a record, like a single record.
Mm-hmm.
Well, do you have an idea of what that was about, or is because it doesn't seem like you're going to audit somebody, you're going to request a single record. Can you talk about what your thoughts are on that?
Yeah, it's a little unusual. We have had some clients who have gotten requests for records from the OIG for like 1 or 2 patients for like a discrete date of service. And I think that they're sort of using that ability to do some, poking around. So you'll submit the record to the OIG, and then invariably the OIG is probably going to come back and say, hey, well, we know that we asked you for this particular record on this date of service, but we would actually really like to see the entire episode of care that you have provided for this particular patient. So at least that's been my experience when it starts with the request of a single document, because there's usually a follow-up request behind it.
And is that from an audit of the doctors, is an audit of the program, right? Because the OIG also audits not only the providers, but they also audit Medicare itself, right?
Correct. So, yeah. So
you talk about that.
Yeah. So it could be either. Right. So the audits that the OIG does from the Office of Audit Services, they are generally sort of focused performance audits. Sometimes those audits look at individual, like they may look at a practice group, or they may look at something that's kind of a bigger picture item. Like, for example, is skin substitute, the use of skin substitutes, are they being billed and documented appropriately, right? So they may be also requesting that information as part of a larger audit that they're doing, kind of on a nationwide level, where they're picking providers and they're asking those providers to provide documentation, because they're taking kind of a sampling of records from providers across the country to see how they are doing with their billing, coding, and documentation. Now, the results of that audit could go one of 2 ways, right? It could be that they then, look to the providers if there's an issue, but it also could be that the report that's being generated is one about CMS, right? And how CMS is either, doing or not doing, what it's supposed to be doing. As it relates to, their reimbursements of the use of these products.
Thanks.
Yep. So one of the things here that is really important, I think, is to have a plan in place, and to have a plan in place before you need it. Right. As I said, if you're in this area long enough, you're going to be contacted by someone. It could be a Medicare administrative contractor. Maybe it's the UPIC. Maybe it's the OIG. Maybe it's the Justice Department. Right. And in the previous slide, we talked about the importance of having a robust compliance program. right? So gone are the days of that sort of being an optional element of participating in Medicare and Medicaid. The government expects you to have a compliance program, policies, and procedures. And those policies and procedures might touch on a lot of things, like a policy against taking kickbacks, for example, or different types of policies. One of the policies that should also be in your compliance program is how to respond when the government comes knocking. Because oftentimes people, understandably get nervous, they panic, they say or do things that they maybe shouldn't do. And so from the provider side, one of the things that you want to do is you want to have this policy in place and sort of train your folks up on it so that they are aware of what they need to do and what their role is if you get an outreach from the government, right? I'm not going to spend a lot of time on this because it really could be its very own topic in and of itself. But what I would say is, again, there's lots of different federal agencies. We talked about some of them. It's important to know who's doing the knocking, where and when and how they're doing it, right? So what I would say is the key takeaway from this is what's down at the bottom of the slide. There is an inherent power imbalance. If the government is coming to you and requesting information, whether you're a target or not, there is an inherent power imbalance. They have information or know things that you don't know, or maybe you do know it, but they know it too. And if you don't know it, they're not going to necessarily share it with you at that time. The other important thing to know is that all of these auditors, all of these investigators, they receive special training on how to elicit information from you. And they're eliciting that information because it's in the government's best interest. It's not in your best interest necessarily. And understand that, unless there might be some very unique people on this call, but for the most part, people are not, the average provider or person is not trained in this way. The other point that I would make is never respond without consulting an attorney, right? There are certain circumstances where you may have to respond, for example, if someone shows up with a search warrant or something like that, but typically there is a lag time between when someone at the government contacts you and when you have to respond. And you should be using that interim period of time to talk to an attorney, right? Establish a relationship with an attorney before you need one, because the failure to sort of consult with an attorney, as I said, people panic, they get nervous. Oftentimes they want to give everything to the government to sort of get them out of their hair, or they don't want to talk at all, right, to the government. And so you kind of have to thread that needle, and having qualified legal counsel can help you do that. The other thing I would say is just a note about cooperation. If you get outreach from the government regulators, your job is to be cooperative, right? But only to the extent required by law and only as your attorney authorizes you. And to the extent that you have to do something, you want to share, for example, that you're doing it because you're compelled to do it by law, not necessarily because you want to do it. But you're, again, in the vein of being cooperative with government administrators or regulators, that's what you want to do. Here, again, and understand too as well, part of your policy for dealing with government regulators is going to identify a particular point person, right? You want one person speaking for the organization. You don't want many people speaking for the organization. That leads to sort of chaos. And the other thing is that you want to be able to train your people how to respond in these situations, because it becomes less stressful once people have training. Understand who's speaking for the organization and make sure that you have one point of contact who is going to be producing documents, and to train your folks, hey, listen, you're not authorized to speak on behalf of the company. We have this person, that's their job, and we're going to do it this way. Again, it kind of limits the anxiety, I think, when that happens. All right, and also remember that to a fashion, you're not necessarily compelled to speak with an investigator. If they come to your house and show up on your front doorstep, or if they show up, and try to talk to you on the sidewalk, you're not necessarily obligated to speak with them, in the absence of having an attorney represent you, or the entity that you're working for. So again, it's just being mindful of the fact that there's lots of different ways that you might get contacted. And again, it's important to have a plan in place before that happens. All right, I'm going to turn it over to Dr. Kapp, because he's going to share a little bit about building the right team and why that's so important.
So, I'm a plastic surgeon. I'm in a solo practice of plastic surgery. When you're in a big organization, the big organization has an accounting team, they have a bookkeeping team, they have a compliance team, they have an environmental team to clean up the office. But when you're a solo practice, it's really hard to understand what team you need to have. But there really is a team that you need to have in your camp from the start of your practice, which is when you open up your practice and you prepare the creation of your entity, right? You can create the entity as an individual. You can create the entity as a corporation. It can be the corporation that bills on your behalf. The Medicare could be the individual. When you receive contracts, how do you review the contracts? Who reviews the contracts? Well, the truth is, right, you have an attorney review your contracts to make sure your contracts are correct. Now, in the office, we don't get that many contracts through the door, but spending the hour to look at the contract is really important. And you have to have attorneys to help you review the contracts and look at the contract and say, this contract makes sense. How are you signing this contract? Who's signing this contract? We have done now hundreds of reviews now. And what we have seen as providers who unknowingly sign contracts as an individual and not, for example, as a practice. And the contract was really a business to business practice, but the provider was in the process of setting up their practice. So they didn't set up the corporation correctly in order to have the corporation be the contracting entity. So just like you have your accountant, just like you would have your insurance agent, you need to have the attorneys in your stable, right? And this is on an ongoing basis. Ever before you even get close to, having to reach out to somebody because you do get an audit, you have to have these professionals in place. I myself have 2 healthcare attorneys for my practice, one who specializes in contracts, and then another attorney who specializes in the compliance components, because not all attorneys are the same. People tell you that they can do everything, but some attorneys just do healthcare compliance. Some attorneys do healthcare contracts, regulations. Some healthcare attorneys do mergers and acquisitions. So it's really important to understand what type of healthcare attorney you're working with. So, David, what kind of healthcare attorney are you?
So I am as you might have guessed from my OIG background, I am a compliance-focused attorney. I help clients who are being audited or investigated by government regulators, including my former employer, the OIG, the Justice Department, things like that. At Garfunkel Wild, though, to your point, Dan, we have a stable of attorneys who do specialize in other areas. So those who can review contracts, those who can help you with business formation, and make sure that you're setting up your practice in the right way, and making sure that the contracts are written to the extent possible in a way that's favorable to you, and things of that sort. But yeah, it is sort of critically important that you understand and identify, key folks who can help you. Not every attorney is going to specialize in healthcare. Not every attorney is going to specialize in contracts, and it's important to have the right folks on your team so that they can give you the best advice possible and hopefully keep you out of trouble, right? And if you find yourself in trouble, then you're going to want help navigating that process as smoothly as possible too.
And the same thing is true, and I find, and I think, David, I think you do have some attorneys, but even your electronic medical record, those contracts are even different than merger and acquisitions or general contracts, because there's information put into those electronic medical records contracts that determine how they can use your records, right? So I think you have attorneys that do that as well.
That's correct. Yeah, we do. We have attorneys who specialize exclusively in reviewing EMR or EHR contracts to make sure that, again, everything is squared away and that you have access to the records you need when you need them, among other things.
And then we move on to billing and coding. And so every 5 years or 4 years, I actually go to a class for billing and coding. And every specialty, including wound care, has classes and programs for billing and coding that even though you may use a third-party vendor, you need to understand what that billing and coding is for your specialty, because our specialty changes frequently. They change the rules with how we bill the products, what line we put them on, what modifiers we use. And you need to make sure that your billing and coding person is on top of that. David, how often do you see a healthcare provider get in trouble not because the care was bad, but because there were problems with the billing and coding subcontractor?
Yeah, I think it's actually pretty more common than you would think. Providers, frequently get in trouble with government regulators because their documentation is in the eyes of the government insufficient. And I understand that when many of you maybe went to medical school or whatever advanced training that you have, there's a way that they taught you how to document as part of your training, but then that way is not necessarily the same way that the government expects you to document it, right? So there's an inherent disconnect there. That's one of the things. The other thing I would say is, to the extent that you are relying on third-party billers to do your billing, coding, and documentation reviews and submitting claims on your behalf, that's fine. Again, it's important to vet those people, make sure that they're highly qualified, and in particular that they have the special skills necessary to handle wound care and skin substitute claims. And it's also really important to know that even if you use a third-party biller, if the government comes knocking, it's not going to work to blame the third-party biller unless the third-party biller has engaged in outright fraud, which is very rare. And so the government's position is that even if you're using a third-party biller, you as the clinician or the provider are ultimately responsible for the bills that are dropped. And so if it becomes a problem, they're going to look to you, the provider, for the remedy. Now, that being said, we were talking about contracts a minute ago. One recourse that you might have as a provider is a contractual cause of action against your third-party biller, potentially, if you're in that boat. But again, it depends on how those contracts are written.
So now with that, and I see there are a bunch of questions that we'll get to the questions at the end because I want to continue the conversation because this is a really helpful conversation. So I see that you've asked questions. We'll get to those questions. David, in terms of documentation, my experience is, and maybe you can share yours, is that most people have most of the data elements that they need, right? But having the data elements is not the same as telling the story of why. So in your experience, do you see that most people have the data elements and the explanation of why the care was necessary is sort of lacking? What would you say about that?
Yeah, I would say so. And again, it comes down to what the providers know inherently by virtue of their training, right? That if you see something in there where there's a discussion about how conservative wound care treatment has failed, and the next thing you know, in the follow-up visit, somebody's applying a skin substitute. From the provider's perspective, it's readily apparent why that happened, right? Because the conservative care failed, and so now they're moving to the use of skin substitutes. But when an auditor looks at that or a government regulator looks at it, they may not make the same connection. So again, it's writing your notes in a way, and what I tell people is you should write your notes in a way that someone else is going to read them and understand that person probably doesn't have medical training at all, or certainly not to the same degree that you might. So it's important to connect those dots, right? Patient had a 3-week trial of conservative treatment that failed. The wound, the size of the wound increased. It's not healing, and so therefore, we're going to take a different approach, which includes using skin substitutes for the following reasons.
Yeah. So from my standpoint as a plastic surgeon, and we'll talk about that conservative care because that comes up a lot, I think, in what we look at. And what I'll say is, where did the idea of 4 weeks come from? It really came from, if you look at what's called a run-in period for a clinical trial, which means that you want to get the right people in a clinical trial. And so that's how that definition of 4 weeks being a chronic wound or, a failing wound came to be. And, when you do a clinical trial, David, whatever happened before to that patient doesn't count towards that run-in period. And I think the best practice is that if you're going to consider owning the skin substitutes, you got to own the 4 weeks of conservative care. Like, you have to document not only do they have conservative care, but that you were the one who did the conservative care. Because what I see is providers then have to go look and try and find where the conservative care was done. Now, we all know it was done because it's in records, or seeing Jim Bob at the wound care center next to the hospital, but we don't have those records, or the place closed, the nurse moved, the doctor retired, the records aren't available. So I think the best way in terms of documenting those supportive information is to make sure that you've documented that conservative care, and that in your hands as a good provider, that wound hasn't improved and that wound has stalled. Do you have any thoughts on kind of like that kind of logic where you?
Yeah, I think that's right. Yeah, I think that's right. And one of the other things that we see pretty regularly is that the patient will have conservative care done elsewhere, and then they go to the provider, and the provider wants to apply a skin substitute. And from CMS's standpoint, the government auditor is probably going to say, well, did you go and get the records from the other provider? You're not obligated to do that before you use skin substitutes, but it would be important that if you haven't provided the conservative care, to get as a comprehensive history as you can from the patient, and then take it from there, and again, explain, this was the conservative care as it was described to you. And for the variety of reasons that when you're looking at that person now, that treatment clearly has failed, and now we're moving on to skin substitutes for the following reasons.
So being that at one point in your career you were on the side of the evil empire, I'm just using that facetiously, but tell me about like the mindset. Like, I did auditing in the past when I worked for the EPA, right? Tell me about the mindset of the auditor and sort of their a priori preconceived notion about the doctor or the provider that they're auditing. How do they come in sort of, and are they looking to pass people? Like, what's their mindset in terms of how they approach it as the auditor?
Yeah. So I think it's a good question, and I think it depends on who's doing the auditing. Right. So, for instance, if you're being audited by the Medicare administrator contractor, their focus really is on making sure that, for example, you're complying with the local coverage determinations, national coverage determinations, et cetera. There are other times where you're going to be audited by the UPIC. And this is maybe a little bit outside of the scope of this presentation, but the issue with the UPIC is that they get to keep a portion of the money that is collected in clawbacks, right? And so because of that, from my own personal perspective, that makes it more challenging, I think, to go into it with an objective or clean set of eyes. Right. So you may, if in that situation, they may be able to do it objectively, but also they may also have an incentive to find problems that may not be there, or may not be as big a problem as they might make it out to be. So, and I think, and again, to the extent that you're being investigated or audited by the OIG or the Justice Department, my experience in working with them and doing that work myself is that they're they're objective, as objective as people can be, right? They're not looking to persecute people unnecessarily at the OIG or the DOJ, but they'll go where the evidence leads. And if there's evidence of fraud or some other misconduct, they'll track it down to the end.
So now one of the things, and David, I know you know this. I'm going to ask you about this, and we're kind of leading more into like the why the medical experts, right? Most of what you see is based upon this medically reasonable and necessary, right? And so there's medically reasonable and necessary. That's a statutory thing, right?
It is.
And then we have in medicine, we have different thing. We have SOC, or standard of care. Sometimes they clash, right? So you have standard of care, and then you have medically reasonable and necessary. How, in your mind as an attorney, do you balance the difference between medically reasonable and necessary and standard of care treatment?
So I think when you're sort of evaluating these things as an attorney, the overarching consideration is first and foremost is there a national coverage determination or a local coverage determination that guides how a particular product should be applied or used or billed or reimbursed or whatever. If so, that is what controls for the purposes of the audit. If there as you know, there are some jurisdictions out there that do not have LCDs or NCDs related to things like the use of skin substitutes, right? And in that case, the issue is the care that was provided medically reasonable, necessary, and appropriate? And that's really based on, kind of a look at, what is the general medical community doing? Right. And the easiest way to kind of get your finger on the pulse of what is the standard of care? How does the medical community treat this particular issue or do these types of things? The only way that you can really understand that is to either be an expert in that yourself, but also to, solicit feedback or guidance from others in your field who would be expert in it too. Because that's also going to lead to the next thing, Dan, right, that we're going to talk about is the Medicare appeals process.
Right. So what I want to talk to you, switch a little bit, was about the medical expert, right? So why do you need a medical expert? Well, you need to be attending educational programs so that you can demonstrate that you're working with optimal efficiency, not that you're just doing a procedure, but that you've been educated on the procedure and you're continuing your education on the procedure. The importance of medical experts, as I see it, and I review a lot of charts, I testify as a medical expert in cases, and what it is framing, because the system does not understand the context of the care. The system doesn't understand the alternatives or lack of alternatives for the care. The language is being interpreted by non-physician, non-provider professionals, right? Maybe paralegals, maybe attorneys, it may be nurse auditors, and the expert is able to take those documents and frame them and further validate both, I think, in my mind, the standard of care, explaining how long the standard of care has been the standard of care for, right? So, and I'll give you an example in our world of wound care, for example, compression wrapping the leg. Okay, I go back and I do all this, as Howard said, history of medicine, and I publish it on LinkedIn. I can go back to about 1745 in the actual published medical literature and find documentations of surgeons back, we're talking about before the Revolutionary War, documenting that they need to put as tight a possible bandage on the leg because it helps heal the wound. That's standard of care. We go back and we can find from 1850 doctors using camps, right? I don't like the term skin substitutes because these products are not substitutes for skin, and camps defines what the products are, and skin substitutes really is it's a lay term, and I don't like to introduce lay terms into medical speak. But I think the importance of having a medical expert is, one is to help frame, number two for education, and number three to comport in a simple way that this is what all providers are doing across the country. So where there is no LCD or NCD that exists, this is how the practice of medicine is taking place today. I'm going to switch it back to you now for
Yep. So I know we're coming up on time, and we want to make sure that we leave time for the questions. And so our comments on the Medicare appeals process is going to be brief, but here's what you should know. The Medicare appeals process is a long process, and when you're being asked to pay back millions of dollars, it's critically important that you understand your appeal rights and that you assert those appeal rights. A lot of times people would say, oh, if we just pay the government the money back, they'll leave us alone. That's not the case necessarily. And you also miss out on an opportunity to share your story. As Dan mentioned, the importance of framing, right? This is why it's important to have the team of billing and coding and documentation experts, medical necessity experts, and the lawyers, right? Because the lawyers frame the argument in terms of legal terms, and they incorporate the framing that these other experts provide, right? And they synthesize the response in that way to give you the best opportunity to be successful, right? And so, again, my 2 cents would be, if you're faced with the opportunity to appeal, you should probably avail yourself of that opportunity, but don't go it alone, because people who go it alone tend not to be as successful, because they don't understand kind of the ropes or the rules of the road. And also, just real quick, you see here that it's a 5-level appeals process that ultimately ends in federal court if you elect to take it that far, right? But what's really important about this is at levels 1 and 2, so redetermination and reconsideration, those are the opportunities that you have to introduce evidence and make the strongest cases that you can, right? Because after level 2, it's infinitely more difficult to introduce new evidence at the administrative law judge level or beyond. And that's because the standard is higher, and you'd have to show that either the evidence wasn't available at the time, or that it's new and material and you couldn't produce it, right? It's a very high burden, and it's generally people are not successful in trying to introduce evidence at level 3. So again, level 1 and 2 is sort of where your best bet is. And that's your opportunity to create the record. And if you miss that opportunity, it becomes infinitely more difficult to be successful on a going forward basis. The last thing I want to say, and Dan, feel free to jump in too, before we head to the questions, is this. I said jokingly at the beginning of this conversation that I would tell you what my favorite 4-letter word is, right? And hopefully your imaginations run wild over the last 45 minutes of this, but my favorite 4-letter word is actually help, H-E-L-P, right? When you are faced with, government audits and investigations, the first thing that you should be thinking is, I need help, right? The stakes are too high to go it alone. Your reputation, your practice, and your livelihood depend on it.
Yeah, what I would say is and I've been on the receiving end of it, right? So what I would say is it's about the construct of a team and a team approach. And like anything, these are just parts of the business of healthcare. And it's really hard to separate the sort of moral injury, because we took really good care of the patient, and then somebody comes and they say, we're auditing you because. And it's really hard, and you have to separate that moral injury and be pragmatic, which is, that's fine. The process of healthcare is thankfully a very rewarding process, both financially and emotionally and personally, and part of the responsibility then is, when you get audited, is to prepare a team. And nothing is for free in this world, as my dad used to say. So you have to sometimes pay money to people who are more expert than you in following the good care that you're providing patients. And I don't think that necessarily an audit means that you're providing bad care to the patients. What it was they spent a lot of money and they want money back, and they're looking to you to provide a portion of that money that you received back, because that's their job. And your job is to take care of patients. And David's job, or another attorney's job, is to help with that process, to short circuit that process, because the care was good and the care was appropriate and the care followed good guidance. And I'm going to turn to, I see Howard popped on, which means that probably want to switch quickly to get some questions. There are a lot of questions that have come through.
Yeah, we're running late here. That was great, guys. Really helpful. Folks, we're not going to get to all these questions. I'm going to try to ask a couple, but please, follow up with Dr. Kapp and Mr. Traskey offline. And I think we might have another episode where we try to get some of these questions answered that are specific. But
Yeah,
just to highlight what
Howard, we're happy to come back, and also, there are the participants should get copies of our slides today. So my contact information and Dr. Kapp's is there. They can also feel free to reach out to us that way.
Yeah, perfect. And just to kind of highlight what was said by our distinguished guest, get some help. I mean, this is a adversarial process to a certain extent, and you need people to help you. You need a good lawyer and a good expert. I actually testified once. I didn't do as good a job as Dan definitely would for you, but it was really revealing to the ALJ, and that's essentially what he said, because the auditors are up there saying a bunch of malarkey. And so having someone with some credibility say, no, that's not the way it was. This has been going on for 15 years and CMS was fine with it until 2 years ago. That's kind of what he took home from it. And my friend I was helping won. So get some help, have someone besides yourself, helping you tell the story and being able to testify and be listened to, I think is enormously valuable. So
Yeah,
a
I
couple
wasn't
quick.
hearing, real quick, I wasn't hearing, and the actual administrative law judge said, oh, you mean so the government actually overpaid for all this stuff, and now they're coming back and asking you for money for something that they set the prices to. They agreed to the way the prices were being paid, and then all of a sudden it was being paid, and surprised, they're angry at the provider. The judge said this, which just sounds like the Defense Department and what they do to Lockheed. And the judge said, on the bench, case in the favor of the appellant. So
I have a question that kind of sets this up for you guys, and we may only have time for one, but someone asked in regard to, hold on now. The appeals process seems templated at many levels, even with lawyer assistance. How do you avoid the denials happening without any real review by qualified people?
Yeah, it's a very good question. It's a very good question. I would say that unfortunately, because the vast majority of the Medicare appeals process is held in-house at HHS with administrative law judges, you have to prepare yourself for a long road. Historically, I think people, especially those who are appealing skin substitute cases or claims denials, have been largely found success to be very hard to come by at levels 1 and 2. I think where you start to get some traction and you see some success is at the level 3, when you're able to actually present your arguments in person to an administrative law judge and have your medical expert there with you shoulder to shoulder, explaining in layman's terms the medical rationale for what you have done. And so I think that, again, the steps 3 and 4 are probably where you see the most traction. I'm not aware of too many cases that have gone to federal court yet, but I suspect that there will be several, based on the approach that the Medicare administrative contractors and the UPIC and the like have taken in denying these claims, many of which were medically reasonable, necessary, and appropriate.
Yeah, from my standpoint, a number of the medical specialty societies are gearing up to actually send letters to CMS and the OIG, because the audits are templated, and some of the templated nature are really discriminatory and really are not actually looking at the care on a case-by-case basis.
I agree. All right, well, that's it for our time. As I said, we will do our very best to get all your questions answered in another forum, but please feel free to reach out to Dr. Kapp and Mr. Traskey. You could not go ill by using them for advisors, but if you don't use them, use someone. And, from the overall perspective, I think pushing back on these audits is the only way to make them stop. They will continue. If people give in, they will continue to go. So let's all
100%.
get
You are
together and
correct. Yeah.
yeah, you got to make it harder.
That's
All
right.
right. Thanks
Absolutely.
everybody for attending. I mentioned that the recording of the presentation will be posted to YouTube, and we'll send you an email when that's ready. We have one more event in this series, part 4 of our Wound Care Compliance and Audit Defense Essentials series, scheduled for November 7th. Michelle Lerma of Rogue Medical will be our speaker. The link for registration will be posted early next week, so be on the lookout for that. And again, David and Dan, thank you so much. This was fantastic. We really
Our
appreciate
pleasure.
it.
Thank you for the time.
Thanks for having us.